Associate Solicitor at the Supreme Court of India and the Karnataka High Court. I'm your host for today's conference 1.2 on emerging entrepreneurial trends in arbitration, mediation, and ADR. SK Associates and Group is an internationally certified ISO certified management consulting firm registered under MSMED Act 2006 with the Government of India. We provide consulting services in the domains of compliance, operations, marketing, research and development, human capital, strategy and operations to budding student entrepreneurs across the nation. SK Associates and Group was formed with a dream and a vision to provide consulting services to budding student entrepreneurs across the globe and help them in developing the global economy by establishing their dream firms across various industries. We work with startups and train potential student entrepreneurs who are aiming to bring a significant change, either in their business model, in the scale of operations, or both. To succeed in this endeavor, our clients need a specific type of consultant, someone who is a problem solver. Typically, such a person is entrepreneurial and passionate, thinks out of the box, has an idea where the problem lies, how to analyze it, and most importantly, what will serve as a perfect solution for it. Such people have lived and worked in different continents and countries. They have worked on exciting projects. They have taken risks and have scars to show for it. We call such people transformational consultants. We have worked over the last 3 years to build a network of such people, reaching out to them across industries, across universities, and across the gamut of functional roles. Time and again, we have seen magic happen when we find the perfect solutions for our clients. And this is what drives us and keeps us motivated each day. We are passionate and excited about the impact such individuals can have in building the next generation of iconic organizations in the corporate sector. Our mission and aim is to mentor 3 lakh students across India by 2026 by providing them with consulting services in strategy and operations, human capital, compliance, legal advisory, research and development, taxation, marketing, and help them in establishing their ventures by investing 20 crores US dollars in the startups over the next 5 years. We also aim to provide 50,000 employment opportunities to various lecturers across the nation in the upcoming 5 years. We strongly believe that strategic alliance and collaborations shall help us achieve our vision in working for the cause of global economic growth. Our executive management and operation teams are always dedicated on working towards entrepreneurship development and community impact with a concentration on the point. Students are the upcoming future generations of our nation and need to be empowered for global economic growth. Visit our website to know more about us at www.skngroup.com. Now, I would like to request all the attendees and my fellow speakers to switch on their webcams. Yeah. Further, I would like to commence this conference by uttering a small story. I'm going to start my startup in ADR. So I want to know the cause I should work for. Cause my startup going to make a change in this world? This is a very popular concern every first-time founder from a legal background with a keen passion in conflict resolution and alternative dispute resolution generally has when he or she is starting up and approaches my consultants or any other consulting firms. Prior to becoming an entrepreneur, founders who want to establish their startups in India really doubt if this startup's idea would contribute to this world in any manner. This results in a search for co-founders or consultants from every background to help them understand the impact of the vision, make decisions, devise strategy, and lead operations, execute plans, and many other functions. In answer to all such questions of budding students who wish to emerge as entrepreneurs in the ADR industry, we have organized Conference 1.2 on emerging entrepreneurial trends in arbitration, mediation, and ADR. Now, I would like to introduce all our honorable guests for today. Firstly, I would like to introduce Ms. Viraj Srikishan, who is an advocate, mediator, and founder of Fair Practice based in South Africa. She is a Harvard-trained advanced mediator and negotiator and presides as a judge in civil or commercial mediation and negotiation competitions globally. She is also an internationally accredited civil or commercial mediator and negotiator through CEDR UK and AOI UK. She has obtained an LLM with a distinction merit for her dissertation on mediation in family law. She has extensive experience in civil or commercial, family and workplace mediation since 2013 and has featured on all media platforms, endorsing the use of mediation. She is the settlement counsel and advisor to multiple tech companies on how best to negotiate and settle disputes that have little to no impact on the end user. She is the lead trainer for fair practice in mediation and negotiation skills training. Over the past 7 years, she has trained over 450 professionals from all sectors. Our next guest for today is Raphael Lobo Miembro, who is a consultant in mediation and conflict management in Monterrey, Nuevo León, Mexico. He was the founder and director of the first municipal mediation center in Mexico in 1999. He has been invited as a speaker in multiple seminars, regional, national, and international mediation congresses in many countries in the Caribbean and South America, as well as the US. He is also a member of an international panel of commercial mediators at the International Center for Dispute Resolution, ICDR, the international division of the American Arbitration Association, AAA. He is the first certified mediator by the state Supreme Courts in Nuevo León, Mexico, and other 3 states. Mr. Lobo is the first Mexican to be certified by the International Mediation Institute. He has been designated as a mediator for the World Bank of Mexico, Central America, and Caribbean for internal matters since 2011. In 2022, he became part of the International Global Panel of Mediators for 5 different agencies of the United Nations. We are also pleased to have Natalia Omuridi Almeida, who is an international lawyer and mediator of judicial and private conflicts and the current vice president of EPAMED, Associação Paulista de Mediadores e Conciliadores in Sao Paulo, Brazil. She holds the following experiences of repute: supervisor of mediators for the National Council for Justice, mediator at the Judicial Center for Conflict Resolution and Citizenship, CEJUSC, 7 years, treating around 20 cases per week, obtaining agreements in approximately 80% of them, working with individuals within the family, including divorce, custody, alimony, and visitation matters, working with companies, covering conflicts between consumers and leading national and multinational companies in the following segments: automotive, civil aviation, financial communication and advertising, digital telecommunications, education, and insurance. We also have Kevin R. Scudder, who is a collaborative attorney, mediator, writer, trainer, and inspiration behind the Seattle Collaborative Law Center, PLLC, based in Seattle, America. He is a board member of the International Academy of Collaborative Professionals, IACP, www.collaborativepractice.com, regular contributor to the collaborative literary community, and past president of Washington State's statewide collaborative organization, the Collaborative Professionals of Washington. Kevin is also a contributing author to the book issued by the American Bar Association, co-edited by Adam Cordova and Forrest Woodley Mostyn, on developing a satisfying and profitable peacemaking practice. Now, I would like to invite Advocate Riddhi Bhanushali. Thank you.
Greetings everyone, I am Advocate Riddhi Bhanushali, a practicing attorney at Mumbai High Court and enrolled with the Bar Council of Maharashtra and Goa. I am Shravan's co-host for the Conference 1.2 and Chief Strategic Alliance Advisor of SK Associates. And even throughout my career as a lawyer, my favorite question that I always ask such founder is, are you sure that you realize how your startup will contribute to the ADR industry? Since you all have to guide and direct your board of directors, employees, head of departments and related teams in HR, finance, marketing, research and development, compliance related issues, and even technical development. So you need to know the impact being created to speak of how you and your startup can contribute to the role of the society. That's what is the major role of any startup in any industry. However, today we shall know more of this subject from our esteemed guests who have years of expertise and practice in ADR as attorneys, associates, authors, and entrepreneurs. Now, I would like to request all the guests and attendees to kindly switch on their webcams during the conference. I would also like to inform all of you that Ms. Vaishali Shri and team are conducting polls in the chat box throughout the session. Kindly participate in them actively. Now, I would like to invite Ms. Viraj Shri Kishan, founder and CEO of Fair Practice from South Africa, to commence a speech.
Thank you, Advocate Riddhi. Am I audible?
Yeah, you're audible.
Thank you. Hello to all the viewers and to the hosts. Thank you very much to SK Group and Associates for the invitation and opportunity to speak to you all today. As you've heard, I am Viraj Srikissoon from Johannesburg, South Africa, and I'm glad to be here. Happy Independence Day to all of you celebrating. Under the conference topic of emerging entrepreneurial trends in arbitration, mediation, and ADR, my focus topic will be on entrepreneurial trends in mediation within the commercial sector. Now, when I was preparing for this, I came up with two trains of thought I want to talk to you about today. The first is the choice to mediate before litigation, which will lead into my second thought, which is how to bring your mediation practice up to speed with practices from around the world and in the interests of your potential client. As is known throughout the world, mediation as a dispute resolution forum comes with the benefits of a quick, cheaper, private, and confidential process that is client-centric. We see, and certainly in my practice from the disputes I mediate, businesses and the private sector are more inclined to choose the option that gives them results sooner. It has become common practice here in South Africa for workplace disputes and commercial disputes to be resolved amicably. This is largely because of changes in the law, which makes it mandatory to consider mediation before commencing litigation. There is a trend here to preserve the relationship between disputants with the least amount of adverse effects on their resources. Now, as a case study on the influence of ADR in business, I looked at the experiences of Mitchell Kapoor. He is the co-founder of Lotus Development, a company that went public in 1982 before being acquired by IBM in 1995 for $3.5 billion. Now, Mitchell Kapoor is responsible for the creation of Lotus 123, a spreadsheet software. And he explained why he believed in alternate dispute resolution in an interview for the book Founders at Work, Stories of Startups. In this interview, when asked what mistakes he made about managing his business, Mitchell Kapoor spoke about his lack of understanding of managing people and not building a good management structure. He also believed his cultural biases that influenced his entrepreneurial skills held him back from hiring the right people. Added to that, his focus was to create products and be creative. He wanted his company to reflect his personality and interests the same way Microsoft reflected Bill Gates and Apple's Steve Jobs. What he did say he firmly believed in was that he wanted to set aside the business culture and instead make treating people well the culture of his business. When disputes arose within his company, he ensured that they invested in alternate dispute resolution conflict management approaches to improve employee relations and the quality of work-life issues, with one of the outcomes of this approach was to improve on the corporate value of collaboration. This led to the company never having any employment discrimination lawsuits and developing a diversity committee that included LGBTQ+ representations. Now, Mr. Mitchell reflected that the success of his company was that they listened to their employees, and by using ADR approaches, it gave them that platform. What he noted from the decline of his company once he had relinquished his control was that his successor did not uphold the values of collaboration and putting the employees in decision-making siege, which ultimately led to the disassembly of all that he had built up. What is profound about his interview is that he notes that one of his regrets was engaging in lawsuits against competitors because it was the traditional way, but it came at great cost. He stated that they had this underhanded way of doing business, as we know it, to build a capital, destroys relationships and leaves behind distrust. Now, 4 decades later, since the creation of Lotus Development, businesses embrace the benefits of keeping their disputes in-house, largely to protect reputation and to not disrupt the flow of work productivity. The workplace as it stands now is evolving into a hybrid domain of in-person and online interactions. To boost morale, companies have to be innovative in engaging with their employees at the same time retaining good quality staff. To that, the emerging trend is for business leaders to develop soft skills of communication. There's a growing trend to address mental health challenges for employees who struggle to cope with the hybrid workplace. So those who do not cope with the isolation in companies who had now had to move their engagement online, or on the other side, those who find themselves struggling to emerge from isolation since the pandemic. These are among the factors that has led to tension in the workplace with employees, now having to answer to newly appointed managers or engage with co-workers who were probably employed while the rest of the staff were in isolation. Workplaces now place focus on employee wellness and supporting these mental health challenges any employee might experience currently to increase employee retention and employee workplace satisfaction. Nowadays, when disputes arise, entrepreneurs and business leaders prefer a more collaborative approach in understanding the tensions and conflict within their work environment, taking a page out of Mitchell Kapoor's book. Using these approaches allows them the opportunity to understand the needs, concerns, and perspectives of their employees by listening to what makes them unhappy. This is where the dispute resolution process of mediation features as the most appropriate tool to open up doors of direct communication with these disgruntled employees. And entrepreneurs are creative by nature. So any dispute resolution forum that places decision-making capabilities in their hands or in the hands of their employees to create bespoke solutions will be welcomed. Now, I talk to people about conflict resolution wellness, and this speaks to transforming the workplace from a place of contention to one of collaboration and understanding. Especially now that companies and organizations are engaging in more talks of creating policies that address diversity, equality, and inclusion. So difficult or uncomfortable conversations in implementing these policies are bound to create tensions. Offering yourself as a mediator to facilitate these conversations opens up another channel of showcasing your skills. Because mediation practice is about collaboration, and collaboration opens your brand into the market. This means you need to reach out to other mediators in your particular field globally, because you get to learn about practices from around the world and improves your cultural awareness and adds to your toolkit as a mediator. You bring with you into mediations different perspectives and different dispute resolution practices from other countries as part of your own understanding within that forum. And by understanding various cultures, you open up yourself to the possibility of more work creation from different jurisdictions. Now, to add to your collaborative efforts in engaging with like-minded people, jurisdictions around the world are including mediation as part of their civil justice system. This means that the move towards using mediation to commence settlement discussions is on the rise amongst legal professionals. And as a mediator, you need to build your network by finding ways to collaborate with lawyers using the tools of mediation advocacy. By researching the relevant legislation for each sector and the role mediation plays in it, you can create advocacy lectures on the features of mediation, the process, and benefits to the client and the legal practitioners. Because we are in the age of instant access to information gathering, and to keep up with the fast pace of information exchange, mediators have to be innovative in spreading the word on where and how mediation fits into each industry. Now, when you approach people, this involves you laying out any statutory obligations, rules of court, and lawyer codes of conduct in using mediation. You may even discuss the role each player has in the process of mediation, explain the principles of mediation, your impartiality, and the good faith required from all involved for the process to be constructive. As part of your explanation, you can talk about the decision-making required from the parties themselves and your involvement in the process as a facilitator, which gives legal representatives the opportunity to prepare the negotiation strategy of their clients as part of pre-mediation assistance, assisting their clients manage their expectations during the negotiations, as well as reality testing the potential outcomes. In other words, what you're doing is you're letting legal practitioners know that we're not excluding you out of the process. And this forms part of your entrepreneurial skills in building the collaborative approach of your own practice with that of other key role players in bringing clients to your door. Now, while taking on the Internet of Things and the possibility of working from home or being a digital nomad, and this is increasing day by day because people want to save on overhead costs and equipment, it is important to have a routine and develop a self-check on your own mental health and well-being. So make time for yourself to reflect on your goals, your vision, and why you have chosen the path of a mediator. Write down how you are improving your skills to be a more effective mediator and how you are growing from it as a person, for instance. As a mediator, you will be operating in a market where the public and or legal practitioners, they have a belief that mediation may be too good to be true, an approach for amicable resolution, and they will relegate mediation as therapy or counseling for the weak. And you as a mediator, you need to develop resilience to any naysayers of the process and express why you think it works. So to merge into the market as a mediator, you have to have a defined set of values in how you want to conduct your business and a set of ideas and milestones on where and how you want your business to grow. Now, if you've done mediation training, we draw up agendas for our clients in mediation. You need to draw up your own agendas for what works for you and how it creates value for other people. To improve your resilience and your confidence in your capabilities, the mediator's journey, like in many professions in learning, never ends after the first qualification. With online learning becoming increasingly popular, you need to improve your mediation and communication skills as part of your continuous education journey. You must add on to your learning and growth by accessing online lectures and webinars like you are doing today. And in most instances, they are at no charge, yet it gives you the opportunity to engage with like-minded colleagues and their approaches to collaboration. You will also have the opportunity to meet aspiring entrepreneurs who want to collaborate with service providers who can guide them to create policies that build long-term relationships within their own companies. It is common knowledge employees will want to stay with employees they can trust. Mediators know how to create such environments where people are heard and seen equally and treated fairly. Employees should not feel afraid if a dispute arises or that there is a looming case of litigation against them that will cost an arm and a leg. After all, with the world moving at such a rapid pace of advancement, giving people access to justice through mediation speeds the timeline to resolution and will be a welcome relief. As part of being a mediation advocate, do not be afraid to endorse its use in any way you can, using online platforms for such benefit in an age where instant gratification and a quick turnaround time is the selling factor. At the same time, do not compromise on your own ethics to make a quick buck or to manipulate a situation to put yourself in favor over what is fair and just. Be aware that using social media platforms to promote the work you do is known as social commerce, and you can build your brand on these platforms. However, be sure to create a defined personality of yourself on who you are and why you are engaging on these social media platforms. One thing is certain, which will always be on trend, and that is to act with integrity. So be a decent human being in all the work you do. If anything we have learned from Mitchell Kapoor's experiences for longevity in a successful business, Develop a brand that is a culture of your own values and practice that place value on respect, tolerance and collaboration, and stick to it. After all, the internet is forever and can contribute to your rise or fall because digital backlash is real. So anything you post, retweet, or engage in online should reflect your vision for the work you're doing and always consider how it will look to potential clients. People tend to find and share information in an instant, and insincerity can be easily detectable. You are always representing yourself, so be true to yourself and your brand and look for your competitive edge to provide value to your clients. In a 2022 article entitled Ethical Marketing, Examples of Company with a Conscience, it said that today around 92% of millennials prefer buying from ethical brands. That said, the younger generations seem to be more conscious. For them, it's all about ethically sourced raw materials, better working conditions for employees, gender equality, and environment-friendly policies. Therefore, your current and potential clients are in full support of ethical conduct and are more conscious to support a service provider like yourself if they can see that you will add value to and improve their relationship with others. In light of these advancements, remember that mediation is a classic approach and its usage is timeless. You have the tools as a mediator to provide a service that meets the needs of mutually beneficial and socially responsible engagement in the current socioeconomic landscape. So it's up to you to use them well. Thank you again to SK Associates and Group for this opportunity to speak today. And again, I wish you all a happy Independence Day. Thank you.
That was an amazing speech, Viraj. Actually, in accordance with your experience from 11 years as a founder in the ADR industry, you are the perfect person for the conference. So I have just one question over here. Student entrepreneurs nowadays have a lot of passion to straight away go into entrepreneurship. What would you like to suggest to them? To first train as a professional in the field they want to practice as an entrepreneur, or directly down there? Because you do have a great experience in that particular industry, actually.
Okay, so taking on entrepreneurship as a student is actually getting you involved in expressing your creativity. What makes you stand out from everybody else? Why ask yourself, why am I doing this? Always ask yourself why. So using your creativity, because everybody wants to work for themselves. Everybody wants control of their time, their money, their hours, their vacation days. So ask yourself, what am I going to commit myself to? And if I can give that commitment, it's hard work working for yourself because you only have yourself to answer to. If you want to develop and understand good entrepreneurial skills, find someone who is a role model that you can trust as someone who will give you good advice, and ask them what mistakes did they make when they were starting up, and learn from their mistakes.
That's actually a great learning. So, Riddhi, would you like to put some questions to Viraj?
Yeah, I had a question. So Viraj, as you said that there is a professional thing is needed. Like when you when you are into an entrepreneurship or you are opening a startup, you need to be professionally into that field. So now, for example, I am a lawyer. So if I want to get into litigation, I need to be a lawyer. And I need to experience certain things and then go into litigation properly. So is it like that? So did I understood it very well, or there is some misunderstanding from my part?
Are you asking me what does a mediator have to do to be considered professional?
Yes.
Okay. So what you would have to do, of course, is to start off doing offering your services pro bono to get experience. Experience is gold in any industry. And you have to be able to be confident when you present yourself as a mediator. And if you're starting off, let's just say you started working as a lawyer. To switch hats to a mediator, and if you're studying mediation or you getting that qualification of a mediator, you know it's very difficult to sit in that seat of impartiality. So gain experience, give yourself off in different areas and different sectors, and offer yourself to do it pro bono. So offer your services free of charge just to get those hours of experience and to build your confidence, because you want to align yourself with people who are experienced, and what they'll do is they'll monitor and mentor you to say, pick up on anywhere where you are lacking and improve on that quality, and say to you, you didn't do this correctly. And I suggest you focus on these areas of improvement. And you want that not as a criticism to bring you down, but as valuable information to improve your skill set.
So Viraj, one more question from my side. So if I want to go for mediation or arbitration, like I want to choose between the one. I have some conflict with someone. I want to choose either to go for arbitration or to go for mediation. So which one would be the best option? Like arbitration would be the best option, or I need to go for mediation? How to choose between the two?
All right. So depending on type of dispute, complexity of the dispute, for instance, if it's a commercial dispute and there are contracts or clauses in place that suggest that arbitration is the route of dispute resolution, and the parties are bound by this contract, they will go the arbitration route. If the parties are in a dispute where there's an option to first start with mediation to understand the issues, to narrow the issues, to understand what the underlying concerns, fears, interests, everything that mediation unpacks, then mediation is the appropriate dispute resolution forum. So parties need to look at how the dispute has come about, and what it would be appropriate in terms of what they have signed up for, in terms of resolving the dispute.
That was actually a great response, Kash. Now I would like to request all the attendees to put forward their questions, if you have got any. Any questions? Just unmute yourself. Viraj would definitely be glad to answer. Yeah, Amulya, Vandana, Rikita. No questions out here?
Excuse me,
Yeah.
is someone asking or may I ask?
Yeah, you may put forward a question, Amulya, if you have any.
No, so I don't have.
Nitya, you can put forward your question.
Thank you so much. Sometimes it's happened that a case can't be solved by mediation or arbitration. How can we solve and resolve it through in a different manner? Then please help me out that if something is not going with ease, how we can manage clients in that way.
Well, first, I would have to understand the background as to why it can't be resolved through mediation or arbitration. Okay. I mean, has it been attempted, and what were the challenges the clients were facing in not reaching a resolution, or not even using those two processes to narrow issues, for instance, using mediation to narrow issues and reach some understanding of why they're sitting in that dispute. Litigation, what we usually say, is shouldn't be the first port of call. It is ancillary to other ADR practices. It shouldn't be the first protocol, and you shouldn't make a judgment call or use your own perceived understanding of the dispute to say, let's go for litigation, without attempting mediation. So what we do in South Africa is we have a mandatory consideration for mediation, which means we invite parties for mediation. And they then use mediation to decide, is it an appropriate dispute resolution? And at the very least, what they can do is use mediation to narrow issues or reach agreement on some issues, and the rest they can take to the courts. So your first port of call is not to at the outset say, because of the issues in dispute, we shouldn't mediate. Get an understanding as to why there are challenges and why are the clients feeling reserved to not go into mediation first.
Thank you so much.
I have also one question. I'm audible?
Yeah, you're audible.
Okay. Thank you. Good evening, ma'am. Ma'am, I have just one question that I've written down over here. Is that ma'am, before arbitration, we tend to follow the map, which is called the mutual procedure and the MLI, or the correlative adjustments. So which are still in routine, but how much of the confidence of the parties or how much the confidence of the parties have legally increased after arbitration or after the ADR practices?
Arushi, I'm going to ask you to please help me understand what you mean by confidence.
Confidence in the sense, ma'am, because I've read a research paper, I think 2-3 days back, and I've learned that people used to, in a MAP procedure, where the parties mutually agreed, but only the jurisdictions tends to communicate over the issue, and the parties are not being involved. And parties were not involved, but after the ADR practices, the parties have been taken, and you have also said in your speech that peoples have been taken into the consideration, which is the one of the most corporate governance practices which has been appreciated by all over the world. The book you have mentioned. That's
Yes. So people do have confidence in the process, if I understand you correctly. Once they understand that the decision making sits with them, they then feel comfortable to bring their concerns and their interests and their fears and anything that was holding them back from reaching a settlement or anything holding them back from revealing information outside of the ADR process. So when they gain the trust of the mediator, so it's very important as a mediator to work on developing the trust from the parties. And once the parties gain trust in that mediator, they will be more open to reveal information and the confidentiality. They trust the confidentiality of the process. So they are more open to reveal information, and that brings them closer to reaching agreement because the other party now has perspective on why this dispute exists.
Thank you. Thank you.
Any other questions?
Ma'am, so I have a question. So, ma'am, basically, we have to take some steps. Means, first of all, we took a step that we should go for the mediation and then the arbitration. Then, finally, when we have to go the litigation process, so we have to give these particular things. Means, if you are not resolving things, then you go to the arbitration. If you are not resolving things, it's more than that. Then you will go to litigation. So we have to follow all these things. Is it right, ma'am?
Is your question the process map?
Yes, ma'am. What is the process of these things? First of all, we have to go for the mediation, then we have to go to the arbitration, then we lastly and the final, we don't have any solution, then we have to go to the litigation. First, we have to try these all things.
All right. So, Bharati, there isn't a have to. Nothing is mandatory in terms of I have to do this, and if it fails, I have to do that, and it fails, and then I go to the next one. You have to give parties the chance to use the processes effectively. So, where mediation doesn't fail, I believe that mediation doesn't fail. When you bring the parties into the room, it allows, and you've explained the principles, and you've explained that the decision making sits with them and it rests with them. You give them autonomy to make decisions. They then decide this process is not working for us. or something is revealed in that mediation that doesn't make it the appropriate forum. They then may choose an alternate forum, and that may be arbitration, again, depending on the type of dispute, the complexity of the dispute. Sometimes, if mediation fails to the extent that the parties are not, it is not effective, they may skip arbitration and go all the way to litigation. Sometimes they may use mediation to reach resolution on some issues, and they may decide that the remaining issues cannot be arbitrated but would need the decision from a court. Or they can say everything we've agreed on can now be put as part of the court order, and then everything we've agreed on in mediation can be formed part of a court order, and the rest can be determined by a court. So the parties, along with their representatives, will determine what is appropriate in that instance.
Okay. Thank you so much.
Ma'am, just a minute, really. If you could just, Virat, could you just share your email ID in the chat box so that the attendees could mail you? It's like we have got other speakers too on the panel. Or else we could resolve all the queries at the end of the session. That would be the best thing.
Okay, so I need to write email in chat box.
Ash will be dropping her email in chat box to be precise. That's fine? Great.
So one small question I need to ask, that's what, not regarding
Riddhi, you can just go ahead.
Yeah. So I would like to thank Ms. Viras Shrikishan for her amazing speech, which entered the hearts of our audience and shall inspire us for years to come. Now, I would like to invite Mr. Raphael Lobo, Director General of Alumnia Centro de Mediation from Mexico, to commence his speech.
Well, first of all, thank you for the invitation and the opportunity to be here and to share some of the experiences from this side of the world. Here it's 9 in the morning, and I know that it's afternoon or starting the night in some other places. I thought it will be interesting today to share a little bit what it's been mediator here in Mexico, of course, based only in my personal experience. I thought it will be interesting, as it is in mediation, to know each other. So I already have been presented, and thank you for that. And I'd like to share a little bit about where we're coming from to understand why and what is happening in Mexico. We can go to the next one because we only have a few minutes. For some of you to talk and to know where is Monterrey, Mexico, which is the third largest city in Mexico with 5 million people. We can go to the next one. And also some data and information about our country, our system. We are a republic, and of course the ethnic groups, which is a tradition and a heritage from many years. Of course, also congratulations. Today is your 75th Independence Day. We are celebrating. We can go to the next one, because in Mexico we are celebrating last year 200 years from the end of the independence movement, with that finished in 1821, and we'll see how it's that heritage and history affecting the present in Mexico. Mexico is considered the fifth in emerging economy in the world. And here is, I don't know, this is a small video, 3 minutes video that give you a quick view of what is Mexico about, their flavor, their side, their history, their culture. If we have a few minutes, we can see it here in YouTube. If not, we can continue with the presentation. You let me know. As I said before, we come from a long tradition, as many other countries. We have the Aztecs, we have the Mayans. And this is the symbol from an old way to salute among the Mayans, which is in Lakesh, and the other person respond to you, Halaken, which give you an idea of what and how they preserve, and we try to recognize that. And in our constitution today, we recognize and guarantee to those indigenous communities, among other rights, the way they do and how the solution of the internal conflict, how they manage among their traditions, even today, how they sit on together and keep those traditions. So there are many things to learn from those ancient countries and those ancient original people from our country. We can go to the next one, please. And as I mentioned, in our first constitution in 1824, this is important because in order to know the present and the future, you need to know about where you're coming from. And we can see how we have go all the way around in history. It took us a long way to understand, because in the past, in our first constitution, it says that conciliation, it was considered mandatory before even starting lawsuit. It was there, so there were no many trials as it is now, how packed and crowded our legal systems, not only in Mexico, but in many other countries, and what it represents on time and cost for everyone. Today, in our constitution, from after the revolution from 1917, the 17th article of our constitution, it has been reformed. The first reform was in 2008, which gave ADR a constitutional level, which is an important step in building public policy, also to accelerate the process on building a culture on the use of ADR. So it says that the laws, they should provide ADR or alternative dispute resolution mechanism on it. And then in 2017, not many years ago, it's talking about a little bit on what we have in 1824, which tells you that the authorities should prioritize the resolution of conflict over procedural formalism, which means you need to go first to mediation. Maybe this is not the most or the best way to put it. It's not clear, as sometimes the law is not. So it depends on how you want to, the interpretation that you want to bring to this article. I think today, most of the judges are still in the old way to think that you should go first in front of a trial and to face a lawsuit in front of a judge, and not to send or to make mandatory. So this is not maybe the best way to put it, but it's in a way to start. We can go to the next one, because after this reform, same year, we have maybe the most important reform in labor law in Mexico in the past 100 years, that separates and creates specialized tribunals on labor issues for the first time, because before that we only had these conciliation and arbitration processes as an administrative authority out of the judicial branch of our legal system. And what is important, that in this case, I think it came with a better luck that how it was in the 17th article of our constitution, that gives no confusion about that conciliation in this case is mandatory before even trying to go to these new labor tribunals now in the judicial branch of our government. And the result in this is a process that is taking us 3 years to go. We divided the country in 3 different areas. So 2/3 of the country are already in the new judicial and labor cases system. and 1/3 will have to be running by the beginning of October, just a few weeks from now. But the results in this particular 2 years have been very good in the numbers, because they say something about 70 or 75% of all the cases on labor issues in Mexico have been resolved through conciliation processes. And that's good news for everyone, because if you have a judge that in the past had to take 100% of everything on labor cases, and now they're only going to take care of 25 or 30% of the cases, those are the good numbers and good news that we want to hear. And these are the public policies that we need to build in order to gain people's and legal system to believe based on results, on good numbers, and to take the numbers down. We can go to the next one, please. These are only a few of the mediation centers around the country. As on some of the slides in the past, we are 32 states, and basically every state under the judicial system, they have a court annex mediation center who are working well, still with very low numbers, because differently that the labor changes that we make, the rest of the cases, civil, criminal, commercial, family cases, is not mandatory yet. And I think that's the way and the path that mediation is moving in other countries. And I think in Mexico, it's about, maybe in an historical moment, to change that. So it's going to be a game changer once we can get past that law. We can go to the next slide. These are some of the challenges and some of the trends too on the next steps to follow, at least here in this country. Mexico is a 120 million people population country. And as I mentioned, today there's a law, a national law waiting in the Senate to be approved. It's been sitting there for the past 4 years, even that is a mandatory issue by our Constitution, who provides this opportunity for the union, the Congress of the country, the deputies and the Senate chambers, to come with this law. And that also will bring some order on national certification in Mexico. In order to practice mediation in front of the tribunals, you need to be recognized and certified by the tribunals. And each state make their own changes and ideas. So if you go from one state to another in Mexico, you may see that how it varies from the requirements that it takes, or how long, or its value for how long your certification. So that all craziness will end once we will have this new general mediation law. And of course, only one process to become a mediator, and you will be a mediator not only in your state but in the entire country. You can practice in the other 31 states. And of course, the value of the mediation agreement, it's important, of course, for clients, because they wanted to know. They always ask you, what will be the outcome at the end? What will be the value of this document in case that the other part won't respond or won't do their part? Is considered as mandatory, and in case somebody is not doing the part that is on the agreement, you can go with the judge to enforce that agreement. But I know that this is a very lawyer's issue, but in the numbers it's not really important, because the best agreement is not the one that you need to go to enforce. Best agreement is the one that parties do, their parts, and that will be the end of the story. And so you need to take care of the process more than the outcome. The outcome will be only as a result. So if you bring the parties into a good mediation procedure, the numbers says that most of them will do the part voluntarily without any need to enforce. But anyway, in case that you need to do, we need to have enough backup from the law and from the tribunals in case you need to enforce it. And as it was mentioned before by my colleague from South Africa, the use of ODR, not only now because of the pandemic. Internet and computers have been around for many years, and it takes time and effort to understand. I also believe that it takes time for some generation. It's a generation issue too. So I'm happy to talk to new generations who you're already born with one of this, but those who were not in the past, and we grow with no computers, and also you need to consider that with your clients. Some of your clients, they won't feel that comfortable or so friendly with technology. And we as a mediators, in a way, have to become some kind of aid on the way for our clients in order to familiarize them with the use of online dispute resolution. And I'm agreed too with Barrage that you need to work on community mediation, because yes, experience is everything. And at the beginning, sometimes you will need to do some pro bono activities, and there are plenty areas of opportunities to do. I do remember many of my experiences at the beginning. I remember where my kids, they were in school at a certain age, and I started a peer mediation program on the school of my boys, and on a pro bono basis. And I didn't know that time I was opening the first mediation center for schools in my city, And then when it became a public policy, they started to find people with experience. And I was the only one. So another key issue is when you do something in a pro bono basis, it will pay you back more than once. And some of the best projects that I have charged, and I have charged well, I started to do it for free. And also another issue, and then on the next steps to follow for this country is to become part of the Singapore Convention. Hope that it will come soon, because the convention has been there for a couple of years. That will also accelerate the use of mediation on international commercial cases. And what the Singapore Convention, as many of you might know, is not just the use of mediation on international matters, but also to enforce those in the countries that are part of this Singapore Convention. So these are some of the next steps to follow. I know that it's important, to talk about some of the emerging trends on ADR, and I think I already mentioned some to push on to build public policies to make changes on the law, and also in order to make this happen, you need always to be consistent, to never surrender. To be a pioneer in any field imply many of those extra efforts against the system. Sometimes you need to work with authorities. You need to work, of course, with lawyers to open spaces in state bars to provide training for lawyers and how they can become and represent in a better way to their clients, because the systems are changing everywhere in the world. So it's only a matter of time that it's going to happen. It varies from one country to another, but we know for sure that it's going to happen for that. And of course, work with universities, with a new generation to create a new set of mind for those generations, and to find mediation as an option, as the first option, as the best option to take. And I will finish to say that it has to be with your vocation. You need to find what you are good, what is your mission in this world, and to be passionate about it. There's nothing can stop you if you talk by the heart and put your heart on anything you do. And so the results, they will come. It will take time, but if you are passionate enough, you have this clear vocation, and you're consistent, and you are willing to pay the extra mile, you will make it for sure. Thank you very much for the invitation, and I'm here open to listen if you have any comments or questions. Thank you very much.
That was a really excellent speech, Raphael. And secondly, I had a question of you. As you said, in Mexico, the government makes it a compulsion for all the audience or other parties in resolution disputes to prefer conciliation above litigation. So do you think it is effective in promoting peace and equality?
To promoting what? I'm sorry, because I'm missing some of the audio.
Mexican constitution, which allows or makes it a compulsion for every party in dispute to prefer conciliation over litigation. Do you think it helps in promoting peace?
Yes, and you need to talk. This is one thing that I learned from an economist. I was at the airport. He was a journalist as well. And I was telling him, give me a clue on how to sell this, because I have been for many years around, knocking many doors, talking to many authorities, and it's hard to convince them. And he, as a good economist, says, you need to work on the numbers. So we start to work on the numbers, how much it costs, the use of a tribunal, not only for the parties, but for the system. For instance, and I will have to talk about pesos, and then try to convert it into US dollars, I guess. But it's like 35,000 pesos that cost one singular case, and only 4,000 pesos to the system and mediation. So you do the math on that. And then you take how many cases will be allowed to go into mediation, and how many of those will be resolved. And as I just mentioned, we have the numbers now on the labor reform that over 70% of all cases are getting settled on conciliation, which means that it's affects on the cost and on the budget of the government. So to work on the numbers, it's because of course you can always talk about peace, building a community that live in peace, and it's more about principles. But if you want to convince the public, and you want to convince first of all the authorities who build public policies, you need to work on how the numbers will be affected, because there's never enough money in any system in the world to provide all the services. Most of the governments always face those conflicts. So if you try to impact in how to have a system more effective, and that will make that the money from the public can go to other areas that are needed too, such as health and education, or to build a better judicial system, they will start to move in that direction, because nobody in their head will think that it's better to spend more time and more money. That the most expensive money is the one that you don't have to spend.
Yeah, that's Riddhi, if you would have.
Yeah, Raphael, one more question. As Shravan said, that in Mexico, it's necessary to go through conciliation, whether it is a civil or a criminal matter. Conciliation is necessary. So, does it depends upon the nature of the what crime has been committed? Does it depend on the nature of the activity which is being committed, or conciliation is necessary whether it is being of any nature?
Well, right now we only have mandatory conciliation on labor cases. But of course, when we have our legal reform on penal and criminal cases in 2008, it became part of the system. And in a way, you can look to our criminal system in Mexico similar to a multi-door system as they do in the US, which means that the system is decided that you can step out in different ways. And one of those, it's the use of mediation or ADR. I think there's a problem in that system, because I think it wasn't understand the original idea, not on the system, but how they run the system, because that's another issue. You can read it on the law and it looks fabulous, but once you run it, you have to consider how the system will run. And in this case, I think they make a major mistake to put mediation on the hands of the wrong person, which is the Attorney General office, who will decide who is going and who is not. So they are taking that right out of the people's hands and put it in the system, who is no, and I have sadly to recognize, a corrupt system. And if you want to break that by making a better and faster system, you are killing at the same time the corruption. So it's hard in those cases. And the numbers, they talk about 80% of the criminal cases will be allowed to go and to be solved by mediation. But this is from 2008, and today we haven't even reached 15%, because it's not clear that it's mandatory. At the moment that it will become mandatory, I think the numbers will change, and also to go straight to a mediator and not to be in the hands and in the power of a third party on the government, who may have another interest on making some business out of it, and to do some corruption acts, to asking people like, I can send you to mediation, but in order to that, you need to pay, or I will send you to jail. So, and so it's again a good example of a good idea in a very bad way to perform it. You know what I'm saying? So yeah, you need to have this systemical way of thinking when you're building public policy, because once it's on the law and you can read it, it will look maybe very good, but you need to run the movie to see how it's going to look and if it's going to run or not on the direction that you're willing to.
That's the point, actually, Raphael. Riddhi?
Raphael, one question similar to this question only. Like you said that conciliation is not mandatory. But what if conciliation being done mandatory? What will be the change in the economy or the system of Mexico?
In order to make, first I think it's a matter of recognition of our history and heritage in this country, because sometimes people blame us that we are bringing strange ideas from other countries. And that's why I always talk about history first. You need to know your own history in order to take a look to the future, what it might be. And sometimes there are many things in our heritage that we need to consider and to remember who we are and where we're coming from.
Exactly.
And somehow we got lost on the way. We make things so difficult for everyone, so expensive. It takes just so much time. So that's to start, because sometimes people is opposed by nature from something that is coming from outside that you don't recognize as your own, that you don't see yourself reflect on it. So that's why I will say this is nothing new. This is as old as 1824. So and then you start to talk about how you can build a better and more effective system, and talk about the money, how it's going to reflect on your budget as a government to provide most and better services to everyone. And also it's sometimes a battle with lawyers. Some lawyers consider things, mediation, if it's mandatory, as a threat to their day-by-day activities. They're going to be affected on their on their income, and it's not. So those are some of the ghosts that you need to fight against, and it takes time and effort to do, and it's every day, and to invite more people to this side of the street and to see how it looks from here, and to start to build this army of peacemakers and people who wants to live a better world, or better than the one that we receive.
Exactly. That was actually very well explained, Raphael. I would like to request you to just share your email ID in the chat box, so that if any attendees have queries, they can directly mail you.
Sure.
Thank you. Riddhi, if you would like to take over. I would like to thank Mr. Raphael Lobo for his amazing speech, and further I would like to invite Ms. Natalia Omori de Almeida from Brazil to come and speak.
Hi, everybody. My name is Natalia Omori de Almeida. I want to thank you for this invitation. Thank you, Shiravan Kumar, Reedy, Raphael, the guest speaker, Raphael, Viraj, and everybody. Thank you so much. I'm so happy to be here. In Brazil, in São Paulo, I'm a lawyer, mediator, judicial, private mediator, and vice president of APAMEC. It's a mediation association, Mediators Association, Associação Paulista de Mediadores e Conciliadores. In Brazil, we talk, our language is Portuguese. A month ago, I moved to Chile. So I hope I can get some experience here in Chile too. Like Raphael, I think Raphael is Brazilian, but he has experience in Mexico. And it's so important to this event, SK Associates Group. Congratulations, because it's this theme. Shiravan, do you have my PowerPoint?
Not exactly, Natalia. If you just share your screen, it would be great.
Okay, I will try to share.
Yeah.
Okay. Oh, no, I can't share, but it's okay. So, as I told you, I'm from São Paulo. São Paulo has about more than 12 million people. It's a big financial center and culture. And we call Brazil, Brasis, because if you go to the north, south of Brazil, you have different people, food, culture, a lot of multiculturality here. So it's important because I noticed in my mediation session, and the multiculturality is happening a lot. So it's a great point. And as I told you, I moved to Chile, and in the neighborhood of Lobo, and I could already notice differences in the daily negotiations. I called sale ao tiro. Ao tiro is an expression here in Chile that's right now, at the moment, I'm ready. So I like this expression because we have to be professional like this, ao tiro, present. So I moved to Chile. I rented an apartment, and I was seeing roller curtains. And in my head, I already imagined what it would be like and the color of the curtains. The seller asked his first question, "Did you buy or rent the apartment?" I replied, "Rent." Then he showed me different curtains from those imagined by me. It didn't have the color I had imagined or blackout curtains in some bedrooms, which would be more private, because in the seller's mind, everything would be more expensive since I'm renting. On the other hand, he's also right. In the end, we closed the service thinking about my interests and the seller's suggestion. So it's important when we know the mediation, the negotiation techniques, we have to apply this in our life, in our negotiations, in our daily negotiations. So you have to shift the focus from position to interest. Like when I talked with the seller and the seller gives some suggestions. So this is really interesting. And so we have to practice this in our negotiation. So recognize a movement and making it explicit is to initiate an open negotiation. To change the game is to change the frame, shift the focus of negotiation from positions to interests, options, or standards. So this is the magic, I think, the transformation in our lives when you know all these techniques. And as I told you, multiculturality is a very important point. What is it? It's the existence of several cultures that coexist in the same physical, geographic, or social space. It encompasses all the differences that are framed within the culture, religion, linguistics, racial, ethnic, or gender. Multiculturality is characterized by promote respect and tolerance for differences, banish associated prejudice and stereotypes, generate a harmonious coexistence, create exchanges between the different groups. In Brazil, we have a case, Abílio Diniz is very known. Abílio Diniz is a famous CEO, businessman. He has a chain of supermarket called Pão de Açúcar. And he was in conflict with a French chain, Casino. And he's suffering, and the family of Abílio called William Woody. I think you know William Woody. Is a international famous mediator negotiator. And then it was, I will tell the story. It was a very costly conflict, not only for the two of them, but for their families, for the company, for Pão de Açúcar. It was the kind of situation where all parties were losing, and the question is, can you turn around? Can you change the game to a situation where all sides benefit? It was difficult, but the key for William Ury was for Abílio to come to terms with himself. So if we have a problem, we have to understand that we have a problem, to accept that we have a problem. We are in a conflict. So when Abílio comes to himself, everything is going to a great result. So William Ury asked Abílio what he wanted with freedom. He said he wanted the freedom to spend more time with his family, which is the most important thing in his life, and to do business, to be a leader in business. So that's the point. What's the need of your client, of your family? So we have to look for these issues. And in 4 days, this conflict was resolved. He was in a process more than 2 years. And in 4 days, William Ury and Abílio and the French chain, Casino, could solve this conflict. This case was in getting to yes with yourself. So you can see this case there. And it's important when we study mediation, conciliation, negotiation, we talk about the iceberg. So in the top iceberg, you have requests, statements, offers, and behind these statements, you can find values, beliefs, different perceptions, emotions. So pay attention, it's really important. And the Ury concept of position, the statements, requests, and the offers that the parties make during a negotiation. Thus, typically, negotiation begins when one part's position conflicts with the other part's position. Your position is the concrete things you want, the dollars and cents, the terms and conditions. I only seek justice. What does a fair chance mean to you in this case, here and now? So, interests, intangible motivations that lead someone to assume the position, their needs, desires, concerns, fears, aspirations. They are the silent instigators behind the confusion of the positions. You see, so it's really important you explore these interests. It's an exploratory work for the mediator, not only to understand the conflict more deeply, but as a tool to achieve a more satisfactory result of the work in mediation. A good result, it is not given by how much the parties changed their positions, but how much they satisfied their interests. People are not always aware of their needs. So that's why the mediator has to ask. So to understand the simple questions, what does A ask? I ask you to pay me. What does B answer? I'm not going to pay you. Mediator, what leads you to ask this? What does A need? I need to fix the office. What does B need? I have to make ends meet with his salary. You see, when you understand the needs, you can comprehend the request, the statement, the positions. So mediation, which is an appropriate method of resolving disputes, an impartial third party, the trained mediator, is asked to handle this conversation in a highly technical manner. The professional conflict mediator works with questions, the way that best preserves his neutrality and his listening. We call it active listening, to identify in the narratives of the parties the real interests, needs, emotions, which is often found wrapped in the request, which we call position. The characteristics of mediation are outcome-positive method, flexible, willfulness, protagonism of the parties, personal attendance of the parties, confidentiality, and economy of time, money, and energy. So the confidentiality of the mediation process means the commitment to keep confidential what's discussed in that area, as well as the documentation that it is known there. Willingness, this quality consists of the freedom of the parties to make their decisions within the process. Flexibility or informality of the procedure. An attractive feature for those who approach mediation is its flexibility. Self-composition is achieved when the parties, through a systematic reflection guided by the mediator about their needs, their options, and their alternatives, are in a position to make the decision. So mediation is a process that proposes to generate a reflective dialogue and the conversational learning in which people can bond in a different way within a constructive context where innovation, error tolerance, and trust generation prevail. And when we know everything, we know about the techniques, brilliant mind can give in our professional life important results, like case Oi, an extrajudicial mediation in Brazil. The Oi is a big telecommunication. The case Oi is the largest and the most complex judicial recovery process in the history of the country, with nearly 50,000 creditors distributed in all the states of the federation and debts that exceed 63 million reais. It seems indisputable that taking the process through the conventional route would impact the entire Brazilian judiciary, especially that of the Rio de Janeiro, venue of the legal action. Imagine, people. Extrajudicial mediation allows interested creditors to receive amounts negotiated quickly and easily without the need to participate in the judicial process, saving time and resources for all those involved, include the company. The approval of the judicial reorganization process of the Oi group, formed by many companies.
Excuse me, Natalia. I had a small request. Actually, we're running out of time. We just wrap it soon.
Okay. Among the reasons that led to the decision, Judge Fernando Viana considered the fact that the company is one of the largest in the communication sector in the world and the impact it represents on the economy of the country. The extrajudicial mediation of case Oi carried out through the online conflict resolution platform of the Getúlio Vargas Foundation. So it's very important the ODR. The initiative, we included the work of 200 mediator accreditors and trained by the permanent nucleus of consensual methods of conflict resolution of the Court of Justice for Rio de Janeiro. The project, initially used only in the state of Rio de Janeiro, will serve around 20,000 creditors who will receive values. The decision to direct the judicial recovery process of the OI group to an extrajudicial solution was made by Judge Fernando César Ferreira Viana. So my invitation is learn by doing. That's it. Thank you.
That was a great speech, Natalia. The way you elaborated things and the case you elaborated in the beginning, even that was a great example here. Thank you. Actually, I had a question, Natalia. Being a member of 3Cs Met Mediators, an international mediation firm which is expanding across boundaries, what are your thoughts on international expansion in startups in the mediation industry? Is it possible with collaborations, or can it be achieved as a solo entrepreneur too?
Kumar, your connection is a little bit.
My question is, as you're a member of 3Cs Met Mediators, which is an international mediation firm that is expanding across countries. Okay, so in the similar way, what are your views on international expansion in startups in the ADR industry? Mediation startups could expand across boundary with the help of collaboration, or solo startups could also expand.
Yeah, it's really important because we have 3C Met Mediator. In Brazil, we have ICFML. It's important these certifications happen, standards. We have competition in mediation, in arbitration, conciliation. So everything can help mediation, conciliation, everything happen. People has to know. For example, in Brazil, I'm a vice president of association. We create in pandemic TV APAMEC TV, YouTube, Facebook, everything, because we have to be in contact with the society. Everybody has to know. So national or international, we have to share these apprentices. Like we are here talking, we have to interact.
That's actually a valid point, Natalia. Even we had Shijioke and Sonal in our conferences previously as though they are also a part of your. That's great. Riddhi, if you have any questions?
Yeah, Natalia, I had one question. When it comes to ODR, okay, in ODR it's completely online. It's ODR is online dispute resolution. So, is it more beneficial than face-to-face communication in person? Don't you think face-to-face communication in person is more beneficial than going for ODR online way?
ODR has grown, for example, in pandemic moment. Okay. So we could have in our judicial court 100% of digital attendance.
Yeah.
So I think it's really important. If you want to share everything, we have to use the technology as our friend. We have to use all the technologies, and the face-to-face is really important too, because some people doesn't like to do mediation in a platform, for example. So face-to-face is important. But for example, in my case, I like to be in technological way. I think it facilitates. For example, São Paulo is a big city. I have a traffic for 1 hour to go to a place close to me. So I think it is very interesting to use the platforms, ODR, everything. In Brazil, we have chambers that's using this, and everything's okay. They have results. They get some good point in courts, in everything. People like it. The society is knowing these
That's
methods.
actually a great perspective, Nasalia. Now I would like to invite the audience to put forward the questions, if any. Attendees, any questions? Nitya, Bhanvati, Abhishek, Kushi, Raka.
No, sir.
No questions?
No, sir. Thank you.
Ma'am, I have one.
Oh, hi.
Oh, hi. Hi, Natalia.
Arashi Apuri.
Yes, Arushi. Okay.
Great.
Okay. I have one question. Ma'am, before the ADR practices, I want to ask something, that after the ADR practices, is it a way to achieve an entailed version of the uniformity between the taxation laws?
Taxing laws.
No. I've taken taxation laws because I've read that there is an international arbitration. It means if the two taxation laws does not match with each other with their provisions, so they can switch back to the international arbitration. So I've read that. I want to ask that, is these ADR practices are the way to kind of encapsulate these different laws together, so that we could come at a one conclusion, or to avoid these tax avoidance, these issues? I want to.
Yes, when we involve international laws, we have to. It's another study. We have to understand, because we will have some conflicts with tax, with everything. So it depends of the situation in international. Like I told about Abilio and the French case and the other cases. It depends of the situation. But what that's why it's important we know all these techniques of mediation negotiation, because the position can be a specific issue. But what about the interest? When you know about the interest, like in the case of Abilio, he wants to stay with your family, to be a businessman, not suffering like he suffered, because all media knows about it. You see? So he liked this. This is the need. And then everything, that all the process of the companies, everything has a great result. So we have to pay attention about the needs.
That's a great point, Natalia.
Okay, thank you.
Now I would like to request all the speakers to kindly share their email IDs in the chat box. Natalia, if anyone has any queries, they would directly mail you out. Yeah. Now I would like to thank all my fellow speakers for attending this conference, participating in it, and making it an amazing experience for all of us. Tomorrow, again at the very same time, we'll return with session 2 of Conference 1.2 on emerging entrepreneurial trends in arbitration, mediation, and ADR. Until then, stay tuned. Yeah. Attendees, thank you for coping up with us for such a long while. I know the time has crossed a bit. Still, thank you, everyone. Have a great day.
Thank you, everyone.
Yeah. Thank you.
Thank you. Have a good one.